Here, we'll do it after.
All right. Good morning, everyone. I'm going to test the camera. All right. Can people online hear us okay? You getting any thumbs up? Beautiful.
Well, I'm not even sure they can, but
Okay.
I'm listening and I can hear that they're okay.
Okay.
And how many are there?
How many people have we got online?
17.
17.
Wow.
Thank you all for joining us. You're missing out on bagels. But you can
There's still time to drive.
there's still time to drive over after. But thank you very much. I'm Katie Atchison, Executive Director of Cape Cod Climate Change Collaborative. And today we are welcoming Renew Northeast for a discussion on siting and permitting reform led by Nathan Rake. He sent me some more to say, and I couldn't find it in my email because between four of us, there were about 30 emails yesterday, as is the way of preparing for these. So Nathan's going to guide us through the conversation. Do we have questions open on Zoom? So if you have a question, go ahead, type it in. Julia's going to prompt us with those questions. There's a few people in the room here and have a little bit of a dialogue, but do feel free to pipe in. And then also, I'm assuming that all of our information is somewhere on here that used to register. We'll make sure that we follow up, that if we don't address a question or there's a question we're not sure about, we'll follow up later with some information about that.
Okay. Just do a quick introduction of like who's in the room and who's on the call. I know there's 17 people.
Yep, and they're not set up for.
They can't talk.
Yeah.
Okay.
But the voice you're hearing, folks, is Dan Wolf, president of the Cape Cod Climate Change Collaborative.
And the Cape Cod Climate Leadership Council.
Yeah.
Which we are in the transition.
We're transitioning TBA to the Climate Leadership Council to reflect a little bit more on the work we're actually doing. Take it away.
Great. Thank you for being here.
Thank you, Dan. Thank you, Katie, for having us here at the Cape Cod Chamber of Commerce. It's a really nice day here on Cape Cod. Always a great day to be on the Cape versus in greater Boston, especially during this time of year. So my name is Nathan Rake. I'm the manager of state and local affairs at Renew Northeast. Next slide, Julie. Renew is a nonprofit organization that represents the developers of clean energy here in Massachusetts, but also across New England. We advocate for the responsible and reliable development of clean energy. We're governed by a coalition of the large developers of clean energy as well as leading environmental organizations. So this provides a little more balance in our advocacy efforts compared to, say, a more formal utility trade organization. And together we provide a single coherent voice in all matters of energy policy regionally. Next slide. This presentation and discussion is part of Renew's On the Line initiative, more so for the folks online than in the room. If you want to scan the QR code, you can sign up for our mailing list so we can send you notifications about great events like these. Next slide. And then one last piece of housekeeping for those of you who are online. If you want to use the Q&A icon at the bottom of your screen, please submit your questions. I would like this to be more of a dialogue between those in the room and those online, rather than PowerPointing everyone to death. I think we've had enough of that already, and we're only halfway through the year. So without further ado, let's get into the meat and potatoes of today's conversation around siting and permitting. I know, it's a very fun topic, everyone's favorite topic, talking about where we put the big infrastructure and the small infrastructure alike. So let's first take a step back to November 2024. Governor Maura Healey here in Massachusetts signed into law the 2024 Climate Act. This act, amongst other elements, directed the Energy Facility Siting Board, or otherwise known as the board, or the EFSB, to streamline how permitting is done for clean energy facilities. This was a Herculean task, seeing that we are going from a system that is largely deconcentrated across multiple agencies as well as purviews into one single framework. This is something that was accomplished very much so through the fall late last fall into the spring, and in March of this year, they finalized the vast majority of those regulations. I will note that there are two paths that the overall what these regulations provide. They have one for the larger projects, so those which we'll get into in a minute, and those for the smaller projects. However, what this provides is four key areas. It provides an accelerated timeline, knowing that there's by providing certainty around when permits are going to be decided and when applications will be approved or denied, as well as there's greater coordination amongst agencies and equity towards stakeholders, which is something that's vitally important for local communities. Next slide. Just a little bit more of a deeper dive into what was on just at a high level, what was on the last slide. Definitions for clean energy infrastructure, expanded ESB jurisdiction, as well as number of members, as well as those mandatory 15-month timelines for large clean energy infrastructure facilities versus the 12-month for smaller, as well as just other requirements for things like community impact analysis, community engagement, and the like. Next slide. So before we get into just the individual pathways, I want to spend a few moments talking about the classification, because this is something that communities as well as developers and those local regulators, I know we got Sean in the room here who is going to probably have his hands full with this in the next couple of weeks and months. It's really important to understand the classification process and how you can go into and how you have to talk about these two particular projects. So next slide, please. So there's really three categories that I'm put on the slide. The first is generation. Then there's a special carve out for energy storage, as well as for linear infrastructure such as transmission lines. At a high level, what it means that for the large projects, it's generally those projects that are over 25 megawatts in size versus small, which are under 25. And we'll get more into just how this breaks down a little bit further, but again, it's for projects for energy storage. It's those that are over 100 megawatt hours are considered large versus small projects are those under 100 megawatts. And then just one of the caveats with this that we're still waiting to see how this plays out in real time is regarding transmission infrastructure. For the purposes of this presentation, we're going to talk about transmission infrastructure as the above ground line, so connecting substation to substation, not specifically tied to offshore wind transmission lines, since that takes on a little bit of a different flavor, but we can discuss that later on as well. Next slide, please. This is just a side-by-side breakdown of who has jurisdiction, as well as basically taking all of that information that's in the regulations and distilling it into a very simple chart for flow. One of the key things here I just want to highlight at the start is the appeals processes, as well as the review boards, as well, and the permitting timeline. So for a large project, so those that are over 25 megawatts, over 100 megawatt hours for energy storage, those are directly sent to the Energy Facility Siting Board for their review and the consolidated permit. Once the EFSB receives an application, they have to complete that process within 15 months. If they fail to complete that process within 15 months, we get it on. There is I'm blanking on the term. There's constructive approval that is applied, which basically is the bare set of common conditions and expectations for our project that would be suitable to that generation type. However, if a project there is a desire to appeal a project, let's say the EFSB decides to deny an application, those appeals are sent directly to the Supreme Judicial Court. It plays out a little differently at the local level for small projects. For small projects, those have to be completed on a 12-month time frame and are done through the local boards and through your local bylaws. However, if a municipality, for instance, let's say Truro, for all intents and purposes, does not have the resources to be able to meet that 12-month time frame. Upon receiving an application, they have 30 days to punt it effectively to the EFSB for review. And typically that means they have to demonstrate that they don't have the resources, so they don't have the staff or the knowledge or capabilities to adequately judge a project. When that project then reaches the EFSB upon that punting, the EFSB still has to follow that 12-month time frame. Similarly, if a project is rejected at the local level, so this gets into the appeals process. If the project is rejected at the local level, they can appeal it to the EFSB for review through the de novo adjudication. However, the EFSB does not have to accept that de novo.
Who is they? The municipality or the developer?
They in this case is the EFSB. So when the municipality or the project developer does not get a ruling that they might not agree with, they can move to ask the EFSB to go and review the project under the de novo rules. If they decide that if the EFSB does not have to take on the project, they can choose to reject it or to take a look at that review. From there, any appeals are then sent to the Supreme Court. Next slide, please.
You want questions at the end, or do you want?
We can take questions as we go. I think this is a good time too, because there's a lot of.
So for your team, I am a developer and I have a 24 megawatt project talking about generation. And I can make it 26. Do I want to do 24 or do I want to do 26?
It really depends. So this is one of the questions that we've been trying to wrestle, and I think a lot of legal practitioners are still trying to see what happens. We're still in this pre-EFSB 2.0 phase, so the proof will be in the pudding once those first couple projects come through. However, there is some consideration of, when we just look at the Commonwealth in recent months, where some high-profile projects have gotten a lukewarm reception, to say the least, at the municipal level. Do municipal leaders want to always try to punt these projects to the EFSB rather than having to deal with a potentially politically sensitive issue?
But at 26, the municipality wouldn't really have a say.
Correct, but if at 24, the municipality does have.
That's what I'm saying. But if I'm a developer, which process, I can choose either one, because at 24 to 26, I can do either one.
Who annoys you least?
Which project would you? I'm asking a subjective question. I'm asking a question. What would you do as a developer? Does it depend on the municipality?
It depends on the municipality, and there's other factors that might be at play for what your project size is, for why you're going with a particular project size. However, as part of your application, you can't straddle that line of, well, we could develop at 24, but we could also develop at 26. You have to set a set number of megawatts that you're applying for, which you're asking for the application, doing in your application. If there's any additional procedures, so this is something that we talk about a lot with regards to offshore wind in particular, is that you have the generation, you might have or actually more land-based wind rather than offshore. So you have the generation component, but then you might have a transmission aspect. Those are two separate proceedings that will be playing out. One for the generation, one for the transmission. So in this case, if you have 24, you can go to the local level and you can receive your permits, or you can punt it up to the municipality, might punt it up to the FSB if they choose to, or they can adjudicate it at that level. But if you then say want to go and do 26, you go automatically to the FSB. So it really comes down to what does the developer put into their application and their materials. Hopefully that answers.
No, that totally sidesteps the question I'm asking. The question I'm asking is, you're in a room of developers, you're trying to raise investment money. And you have, I can decide to go 24 because I don't want it to go to ES, the Energy Siting Facilities Board, or I can do 26 because I do. And I guess, how are the developers going to look at that? If you were a developer, would you say, no, I want to do 26 because I don't want to deal with the municipality and I can avoid it by doing 20. This sort of reminds me of the housing issue.
This is, so if you're, I mean, if you're a developer, the best thing to do would be go to the siting board because you don't have to worry about having to.
Okay, that's what I thought. So the
It's easier because you have they have all those resources.
That's really what I was asking. So if you're a developer and you have the ability to do 24 or 26, from an investor standpoint,
You get 2 extra megawatts and it's easier to do. But from a practical standpoint, especially given a lot of the federal changes, if you're trying to get steel in the ground, there's a 12-month clock on the municipal path versus the EFSB path, which is 15. So you save 3 months. And now these are just strictly when the municipality or the presiding officer at the EFSB level decides that your application is complete. There is a whole other amount of time that we'll get into actually here in a couple slides that really shows that yes, it might be 15 or 12 months, but there's a lot more work that has to be done before we even get to that.
For the hospitals.
Exactly.
And if it gets referred to the EFB, does it then go to 15 or does it stay 12 if it's small?
So if it's a small project and you don't have the resources in your municipality to make the decision, maybe you don't have a Concom commission for one reason or another, or other persons that have the capacity to take on these projects. When it goes to the EFSB, when it's petitioned up there, it's still 12 months.
Okay, thanks.
Yeah. Do you have any questions online?
No, not right now. Just whether we're gonna circulate the slides, which we will.
We will. So this is just meant to, if you're wanting to be more technical, you can go into the Climate Act and you can find these are the statutes that the particular sections of the Climate Act that spell out where all of this particular information is regarding the consolidated permit, the permitting approach for both large and small, as well as just the consolidated permit pathways. And this is the basis of 980 CMR 13, which is the new regulation. So this is Dan, to your point regarding that 12 to 15 month clock. This really is, I want to highlight that number one. So this is just a hypothetical pathway for a hypothetical large project under that section 69T. I'll skip the pre-filing for a moment. So we get to the point where you apply, you send in your application, and the presiding officer, in this case, because it's a large project at the EFSB or within the DPU, decides that yes, it's complete. So that has to be completed within 30 days. So effectively, that starts the clock. That's month minus 1. So then you go into the adjudicatory proceedings. So that can last through that's the entirety of the process. But during that point, there's opportunities for public comment, there's opportunity for evidentiary proceedings and processes. And then when we start moving towards the latter half, so that month 12 through 15, that's when we start moving into the decision range. However, one caveat in that area that I did not include on this slide is that if we're getting to the point where it is looking unlikely that a decision is going to be made, this is where we start getting into the constructive approval and noticing to all parties involved of the likelihood of constructive approval, which is at that point, again, those minimum conditions that are set for a particular project based on technology type. We'll get more into the pre-filing process a little later in this PowerPoint, but what effectively that means, the reason why that's variable is that it could be anywhere from a 12 to 24 month to as long as the developer and the community wants that process to be, until the developer feels confident that they can apply to the EFSB. There are certain procedures and milestones that have to be met in that period, which I will get spell out a little bit better, but it includes things like mandatory consultation, public meetings, engagement with the Massachusetts MEPA office, as well as various other agencies and community stakeholder groups. Next slide. So again, this is just a quick overview of the consolidated permit components. What a consolidated permit means in this case is it's all of the individual state, regional, local permits. Again, this is just at the EFSB for the large projects that a project would have otherwise needed to get. So it's all wrapped into one. For local permits and approvals, those are handled through the EFSB through it. However, the municipality also can get intervener status in those proceedings. Thank you. And then, just as we've talked about, some of the guidance that is being developed, these are just some of the various attachments that the EFSB has been working on and putting out to educate stakeholders around things like the completion checklist. So these are the required procedure and required bare minimum engagements that a developer has to have in order to move to the EFSB, as well as the baseline standards and conditions and the common conditions and requirements that are overseen by the enforcement agency. Next slide. I'll take a pause just before we get into permanent enforcement agency, because this is where it gets a little more convoluted. See if there's any questions in the room or online.
Nothing online at the moment.
And if you're online, don't forget to drop your questions into the Q&A at the bottom of your screen. Chris
Kowicki, question. So you had on the previous slide timeline of 30 days. That's when the application goes in, and then the agency has 30 days to determine if it's complete. And so basically at that point, you say all the pre-consultation has to be done. Presumably you have to come in with a community benefit plan or a community benefit agreement under, maybe you're going to get into that, but I'm just trying to figure out.
Jumping the gun a bit, Chris.
Yeah, I'm really interested in that. Who determines it's complete? Because a lot of times in current processes, it's never complete, and that's why things go on forever. Is that agencies continually ask for more information, butters, interviews. So if you can sort of clarify completeness versus what happens next.
So I think actually, Julie, if you go forward another slide, or actually back at 2 slides then. Actually, just try to find the one with the the one with the attachments, the attachment list. I think it's
That goes the other way.
going forward. Going, yes, it's right there. So back one. we're a little trigger happy today on moving slides. So what effectively, to answer your question, a community benefits plan or agreement is not required to be completed by the time an applicant applies to the EFSB. Now we'll get more into how that's looked upon by the EFSB. However, what the applicant has to fulfill are at a minimum and satisfied to the presiding officer is the requirements on the application completion checklist. So this is, for instance, having 2 public meetings that are advertised using various forms of media. This includes having a project website with an FAQ, providing documentation of all stakeholder meetings, having a list of applicable stakeholders and groups. That doesn't mean that just because the application is complete that the applicant suddenly can go behind closed doors and develop their product and work through just with the EFSB. They still have to be engaging with the TAP. There still has to be that work that takes place to build up goodwill in the community. What this what this completion checklist means is that they have done the minimum required to be able to at least present a case to the EFSB that they are ready to move forward. At this point, again, this is why it's labeled as variable. The presiding officer can view the application checklist as being insufficient, that there's activities that still need to be required, and there can also be added requirements that are put on to an applicant. So the way I would view the completion checklist is as less of a ceiling and more of a floor by which both developers and communities can understand what is expected of the other in this case. So there could be times when, for instance, your energy infrastructure committee here in Barnstable might want to have a meeting with the developer to have a conversation about the project and want to understand, well, what does this mean for Main Street? Are you digging up Main Street to put in new wires? How are you going to be able to work on this project? That still plays out concurrently to the proceedings that are taking place at the EFSB.
We have a question, Nathan. Do we know how the consolidated approval handles local regs? For example, local zoning or environmental? Does the siting board take the tone zoning or conservation commission, parentheses WPA and local bylaw rulebook, and do the review themselves? Do they work with the local regulators?
So this is in the DOER track. This would be for small projects. What the consolidated permit is, it is a single permit of all local, state, and regional permits that a project would otherwise be required to attain. So if you're a small project and whether your application has been punted up to the EFSB by the municipality for lack of resources or upon de novo review, they do have to rectify that with the local rules. There are zoning exemptions that are placed into the consolidated permit approach, but that is more on a case by case basis, and that is something that is more in guidance at this point.
Great.
Any other questions?
No questions from the audience or from the virtual.
Great. Let's keep rolling. So permanent enforcement agencies, PEAs and PAAS. I'm just going to refer to it as PEAs for ease of the room, and I think P's are a lot better than something that almost looks like PFAS. Don't. Good on you, developer, EFSB and regulators. The alphabet soup continues. So a permanent enforcement agency is the body that would otherwise be required to who would oversee a permit in that day-to-day operation. So what they get in this case is they get to counsel the EFSB on how they would rule on a particular permit. So when a developer brings their application to the EFSB, they are bringing with them a pre-filled copy of every permit that they would have otherwise been required to attain. And then from that point, the EFSB consults other agencies, boards, local governments that would have the jurisdiction over that issue. So if it's a water issue, you might be consulting your conservation commission. If it's an air issue, Mass DEP. And they would be able to provide input on the conditions of that particular piece of the permit and suggest recommendations or changes. And then after the permit is then issued, the permit enforcement agency still oversees enforcement of that portion of the permit. So this would mean that the DEP still regulates air permits, while the conservation commissions and the local levels still can regulate local conservation permits. I want to set this up because this is an open issue that is playing out. There is no guideline of who is the PEA. There's no set box. And this has raised questions around other organizations that potentially would have the ability that would be potentially a party to. In this case, boards of health. Boards of health do have their own statutory carve-outs to oversee a variety of things like noise, nuisance, and other negative health attributes. However, this is an ongoing debate around how those are influencing the proceedings. So currently there's an argument happening around whether a board of health has the ability to effectively supersede the EFSB and the local permitting process as a independent agency. Thank you. And so there was a DPU order that was released earlier this month where they rejected several arguments that were made by the regional or the statewide board of health organization, and that they are going to hopefully start to remedy this issue through upcoming proceedings. Our position is that this is a blind spot that the Climate Act left for the EFSB, and it is something that should be handled either through the EFSB's proceedings in various dockets, or through the legislator, or through the courts. However, the Climate Act makes it clear that at the end of the day, the EFSB and this consolidated permitting process is to issue all permits and oversee all permits, and that having a superseding agency authority would be out of line with the intent of the act. So, next slide. Very briefly, the de novo adjudication. So this is where things get a little more interesting. This is under 980 CMR 14. So again, we're going to look at these two pathways that I've been talking about: the objection and the transfer. So I am a small project developer, and I think I've done a great job, and I've engaged really well. And for whatever reason, the town that I'm trying to develop in rejects my application. I can elect to have that go to the EFSB. If the EFSB decides to review it, they have 6 months to reach that deadline. As we've already discussed, if you're a local municipality and you don't have the resources, then you can transfer that proceeding to the EFSB under that 12-month, and they also have that same 12-month runway. These decisions are also all made by the EFSB board director, and so expect they're going to have their hands full coming up with a lot of these de novo reviews. Any questions on de novo before we jump into the small track, which I think is more along the lines of what folks in this room and online will probably be dealing with more of than the larger projects, since those will be squarely put within the EFSB, and you'll be here working more within that pre-filing framework.
The question of
All right, let's get into the small stuff. So this, for everyone's awareness, these are the types of projects that tend to fall outside of Renew's purview, but it's still, these are the ones that you're going to be dealing with on a more readable basis. Still early in the morning. So again, similar to the EFSB, it's a single decision, just on that 12-month clock. With one area that I will provide a little bit more context on is that while the regulations have been finalized, there is a regulatory pathway for municipalities. A lot of it is dealing with the fact that the DOER recognizes that in all 351 cities and towns, that there are 351 various sets of bylaws that might need to be changed or brought into compliance. So at a minimum, by July 1st, so in 2.5 weeks, give or take, every municipality has to provide at least a pathway for small projects. However, that can be extended to as late as October 1st to allow for various changes. This is different compared to the larger projects where it's July 1st, that new process starts. So this is provide a little bit more time for local leaders and electeds to start thinking about what changes need to be made.
Does the new pathway also have to be a consolidated?
Yes, it still has to be the consolidated pathway, but again, that by consolidated, it just means that the developer brings all of the permits to the municipality, and then that single entity. So let's say your town council is the one that has final say over any permits, and so your town council receives the permit, it's compliant, then they go to your town energy committee, water, infrastructure, you name it, and they say, because they might be the PEA in that case, and ask them to review individual pieces. When you receive that application, If you don't have the resources, you have 30 days to make that declaration to try to do the transfer to the EFSB.
We have a question.
Yes.
And I think it's similar to what we talked about, but do you think that these law changes will lead to more projects being put forward that are larger than 25 megawatts in order to be a part of the EFSB process? So from this person's understanding, there's only one onshore wind or solar project that is larger than 25 megawatts currently operating in the Commonwealth. So this would be a shift in strategies. So is this like a strategic shift?
So this is more of a strategic shift. Again, to go back to the intent of the Climate Act, it's to accelerate the development of clean energy here in the Commonwealth. This is a really good practitioner's question because we do anticipate that it's easier to bring smaller projects online. The larger projects typically are brought around through RFPs through the various Section 83 proceedings. So in this case, battery storage or offshore wind. Offshore wind, we're going to put that into a separate bucket because there's other regulations at play there. So we do expect that there's going to probably be an increase in these under 25 megawatt projects. What does that mean in practice? Is do municipalities want to deal with these projects? There's been several cases in recent months where there have been where projects have been selecting municipalities and they've gone through public engagement, and there's been pushback. And then municipalities want to absolve themselves of having any responsibility to oversee this project. So it either results in the project withdrawing itself or it becoming highly contentious. So at this point, what prevents the municipality from, whenever they see a project, wanting to transfer it automatically, because they don't want to have that politically sensitive football on their hands. So that's something that's going to be something that we'll be watching carefully as it plays out to see, does it become just a pipeline where everything is going, or 95% of projects are going to the EFSB under this 12-month process, or do municipalities take the time to want to have greater control over their energy future and take care about the local level?
Is there a situation where the EFSB decides that a town has sufficient resources to deal with it and is like, you can't pass this off to us?
So you have to apply to it. You have within that 30 days, and you have to provide a good cause resource. If it's, for instance, if you say like, oh, we've got like 50 of these projects, there might be some conversations that have to happen behind the scenes between the town and the EFSB to just say, we have a lot of these projects, we don't have the resources to do it. Is there a way we can try to manage some of this workload and move to make it so we have the easier the projects that you can potentially get done in that 12-month versus moving the projects that might require a bit more lead time.
It's a great discussion kind of area.
Does the EFSB have the resource? Let's say all 351,000 decided to apply for the EFSB. Do they have the resources to actually do that?
They are hiring. I will use this as a shameless plug to say the EFSB is hiring for folks to join the siting team. So if you know of anyone qualified, send them that way. This again, so there is a tracker on the EFSB siting permitting website. They have a dashboard about how many project applications they've received, how many they've rejected, how many they have approved, and the average time to decision. Again, we're still sitting pre-July 1. So it would be really interesting if we were having this conversation in December or early next year to see where are we at. Because it's going to just also considering other factors in Massachusetts, such as ability to acquire land, interconnection ability, other rights and resources that need to be taken in. I would not anticipate that it's going to be like the 100-meter dash, where on July 1st, we're going to see 1,000 projects suddenly come out of nowhere.
Let's assume for a minute that the craziness ends at the federal level and we decide on a federal basis we want to incentivize small scale fairly rapidly. That is a potential tsunami. I mean, if an administration came in and gave huge tax benefits or subsidies to developers of less than 25 megawatt, then the landscape shifts quickly.
Mm-hmm.
That's not inconceivable.
It's not inconceivable. And at that point, it would be incumbent on the legislator to make the necessary changes to empower the EFSB to take on this greater workload.
Who controls the budget of the EFSB?
The legislator.
The legislature, so they've given enough, what they think is enough resource for them to hire enough to actually manage it.
Exactly.
Okay.
So you can, and with the recent budget that is still going through, this is by Massachusetts standard, a skinnier budget compared to other years. So we'll see how this actually, how that has any implications on the EFSB's work when this new process gets into.
So you have the EFSB has there is a prescriptive time frame that they're operating within. And this is sort of the unstoppable force in the immovable object, because if they have to comply with that time frame, but they get overwhelmed with the number of applications, they have two options. One is to, but that's probably what they'll do, is just refuse them and defer them back to the town, which they have the ability to do, right?
They have
They can refuse.
They can refuse. They can, if you lack the resources, it's unclear how they'll how that refusal process. Right now, it's open season. They don't see many reasons to refuse if you have good cause for being unable to. The other thing to remember is that the EFSB is not like federal DOE, where you have a marine biologist and a bird an ornithologist on staff. They are relying on the other permanent enforcement agencies to be able to review those portions of the application. So it is not just the EFSB. In this case, the EFSB is the final decision maker, but there are other agencies with staff to be able to review these specific portions of an application.
That's supposed to make us feel better.
In a way.
Yeah, no, I get it.
Any other questions online, Julie?
No, nothing else online. Wanna go to the next slide?
Yes. Okay, so the model bylaws. Yes, and I understand your so late last year, the DOER put out 2 bylaws for solar and BESS. And I'm going to clarify something I said last week to you, Sean, is that these are optional for adoption. They are meant to provide a framework to allow for compliance. You do not have to adopt what DOER has proposed. You can make modifications to it, such as to allow for for local zoning exemptions or other issues that might be raised, but you cannot wholesale prohibit clean energy facilities. I think that's really the key point in this for towns, is that when you're thinking about these regulations and you're thinking about that, what you're going to see in this case, it'll most likely be small scale solar, smaller BESS projects. The takeaway is that you cannot wholesale prohibit them. There has been conversations about, well, we won't wholesale prohibit them, but we'll just create a special zoning district where we'll put them in. That special zoning district happens to be where there is ecologically sensitive, or it's a mating ground for an endangered species. It will be your local municipal council's obligation to ensure that your leaders are aware that that will not be feasible, is not a solution.
No tricks.
So no tricks.
Yeah, and the Attorney General's office gets involved and has gotten involved on local bylaws and invalidated a number of local bylaws on BESS and solar because they were essentially precluding any installations.
So that is the big takeaway. I would say you cannot wholesale prohibit, and no tricks.
Okay.
And again, beginning this review is really important because you want to have these in place as early as possible. However, there is no set timeline that you have to get this done by October.
We have one more question, which I think piggybacks, actually 2 questions just came in. So one is, aren't there mechanisms for the regulators to assess costs or fees to the developers for review? including supplemental questions, that is the case at the federal level. Not sure I understand what that means, but hopefully you do.
So,
Well, the first part is, can they assess
so
fees to the developers?
I think it would be more clarification around what type of fees they have in mind, because there is the intervenor support grant program that developers pay into. But that program is to allow for, let's say you have an advocacy organization that is passionately for clean energy, or for like a subset, like you have a neighborhood organization. And they would have a vested interest in a proceeding, and that then they haven't been able to participate because they have been historically under resourced. They can apply for funding, and if they can demonstrate a good cause, how it's going to support the proceeding, not be a hindrance, or be capacity building to raise grassroots opposition to a project. If they get funding, they can use it to hire legal resource, to conduct analyses, and to supplement the proceeding. So I think that's maybe the direction that question is asking, but
I think he's clarifying. Regulators sometimes have structures where they bill the developer for the consultant resources. That's what some federal regulations do for energy process projects. They solicit the technical reviews via third-party consultants and send the bill to the developer. So is that happening?
so this would be through the through that 2630 DPU docket, which is the fees the
It's still
EFSB.
pending.
That is fine. That was finalized earlier this month, and that's just what what a developer has to pay to the EFSB as part of their application.
We have a number of other questions. You want to take them now?
I'll take them in turn.
So one is, do you know when the DOER will issue their final solar and BESS filings?
So there's not going to be any final bylaws. These are meant to be more of guidance. These are viewed as guidance documents. They're not going to be any new regulatory proceeding around this.
Okay. And then the other one is, you might be getting to this, but if the bylaws are optional, what is the compliance deadlines for? What are the compliance deadlines for?
So the best practice would be having something in place by October 1 for the municipal level, so that way it works within that process at the local for those smaller projects.
But are the bylaws optional, or?
The bylaws are optional. They are viewed by DOER as best practice.
But the timeframes aren't optional.
The timeframes are not optional.
That's.
Okay, that's it for now.
I think that's a question that we have in Barnesville about the bylaws. Our ordinance right now explicitly prohibits battery storage. So those are changes that we need to make, and we have other questions. We a few years ago expanded our ground mounted solar photovoltaic overlay district, and in particular on a property that abutted a residential area. And so in working with the neighbors and third planning board, we added more strict regulations relating to screening, stormwater management, land clearing, because that was through a robust conversation with the community, and in particular the proximity to a residential zoning district. And so some of the questions we have is beyond what the bylaw has, how strict can we get? Can we keep our provisions to screening, in particular hazardous materials too? Like, who can we talk to make sure that we align with that? But can we go a step further with any of those provisions based on our community feedback?
So based on our understanding of it, you can have additional screenings or mechanisms in place. Those are compliant. It would be the same as going through the site suitability assessment and having to provide those various other needs. But this bylaw is saying is that you can't prohibit the BESS or solar PV from being developed writ large. So your high level prohibition would be out of compliance, and for instance, a battery developer of less than 100 megawatt hours wanted to build in Barnstable and was denied because you have that provision, appealed straight to the FSB. EFSB would most likely overrule and say they have compliance. Therefore, this project might be approved
So regulate it or lose control of it, basically.
effectively.
Battery storage in Providence I'm sorry, Barnstable is prohibited or above certain.
No,
No, just prohibited.
I mean, you can.
Even residential?
No, you can have like a Tesla, a power wall,
Yeah.
that's fine, but anything commercial scale, like, no.
Yeah, okay.
The other question we have with the bylaw, the different tier categories of residential, commercial, industrial, and agriculture. Are there gonna be definitions for those? I know that you said there's not gonna be a more finalized bylaw, but we have questions for that. I mean, what's the definition of commercial? We have a lot of mixed zone zoning districts. We have zones that are commercial but allow single family, which I know is not great, but zoning was written before. I'm shocked I was here. So just clarification on what, because those provisions of whether you need a special permit or it can proceed with building permit, that's a huge difference of it being
So
streamlined. So we're just looking for clarity on.
the agencies are still developing various guidance documents to help municipalities and developers understand the new regulations. I would just check in with those over the course of the rest of the year. I would also reach out to, I know DOER has some staff that they are responsible for various regions to talk about DOER regulations.
And we have a note here from Margaret at Cape Light Compact. It says that Connor Rocket is the regional coordinator, yep, and reach out. We'll share his information. She said, let her know if
And I
anybody
think,
needs that information.
I'm not sure if Connor's on the call or not. But their information's on the DOER website.
I did reach out to him. Would you?
Yeah, so I would talk with Connor
Okay.
about those particulars, especially when it comes to guidance.
Yeah, and I would definitely look to some of the previous attorney general decisions that have said even standalone BESS facilities have been judged pertinent to solar, and solar you can't ban. So I would look at those judgments, and they may just say your BESS bylaw, out of hand is not compliant. That might make it an easier determination because they've already sort of settled on some of this stuff.
Yeah, I think we know we have to change it,
We're just trying to figure out like
how.
how many changes do we need to make? Can we keep stricter provisions like for hazardous materials in particular? That's a hot button. That we want to make sure that as most as possible, we can keep it to what our local preference is while still meeting the obligations we need to.
So much of hitting the environmental and capacity not only have to do with modernizing the grid, but smartening the grid. And really, I think people interchange those, and actually I see them as very different. I mean, a modern grid is not necessarily a smart grid, but of course that built into the siting regulations. How many carrots and sticks are there relative to going the extra mile with the grid? And really, I see two things. One is sort of smoothing the demand so that, pricing such that we can smooth the demand and therefore not have to overbuild. And then, of course, the other is accepting distributive energy in a much more forward-looking way.
So there is not any carrots or sticks, for instance, per se, in these regulations. These are mostly these are primarily about getting projects built.
Okay.
When we're talking about the build out of the transmission grid and the need for things like GETs and ETTs, that is a whole other conversation that we can have, that I'm more than happy to have with everyone in this room, because Cape Cod in many respects is one of the epicenters of the development of grid scale transmission, just because of the proximity to the offshore wind turbine farms and whatnot. And so it's about playing smartly and doing it in a robust and sustainable manner, but also recognizing that it's going to cost money. And ultimately, at the end of the day, we're always a little bit more money conscious about spending today versus tomorrow and wanting to make it someone else's problem.
But you also don't want to spend it twice.
Exactly.
Build a modern grid and then spend, and then be duplicative when you have to modernize, when you have to smarten the grid.
So
some of us believe we have to do.
So this is where we could get more into a conversation about batteries and the role that they can play, and how if you have a really robust build out of storage, how that can not only complement renewables like offshore wind, land-based wind, and solar. But it could delay that having to either retrofit, gold plate, right size, put your favorite term in, the existing grid. But we also have to recognize that we're in a new environment when it comes to energy. I think we were having this conversation 10 years ago, data centers and AI would have been, we wouldn't be in this room having that conversation. We'd be in a much smaller room with a lot fewer people. Because we're seeing this build out new technology, we have to rethink how we're doing our grid and to be able to meet this new demand. And while New England doesn't have the large scale data centers, or we do anticipate that there's going to potentially be a build out and a need to make sure our grid can support this new infrastructure.
We do have a question about the intervenor grant support, but I think you have a slide on that.
Yeah, so we'll get to that. We'll hold off on
We'll
that
hold
one
that
for now.
for-
Let's skip ahead. I think we're running just a bit behind. No, it's good to have questions. Good. Like I said, we'll share these slides out afterwards. So if we don't get to everything, there's definitely gonna be a slide for that. I'm taking from the ISO New England school of if you need it, there's a slide. So again, this is just the timeline for the DER process. It's, as you can see, it's pretty similar to the FFB, except for it applies just strictly to the local level. You still have that pre-filing, you still have the completeness determination from the municipality, as well as municipal review, the local decision, and then with the only addition is the appeal, if any. And that would be then start that additional 6 month clock that I had on an earlier slide. So let's move on. All right, let's get into some cross-cutting issues. So this is cumulative impact, pre-filing engagement, site suitability, and everything really about the local level and what you're going to want to know as projects start coming forward. So next slide, Julie. All right, I know there's a lot of information on this slide. This is the pre-filing and local and solid consultation and engagement process. On the left hand of the screen are just a handful of the requirements that the developer must do in order to meet the bare minimum of the pre-filing checklist. However, there can be it is encouraged to go above this because more engagement means better results for both communities and for hopefully developers. Fingers crossed. But at a bare minimum, the basic design is that it provides flexibility. There's no specific timing for pre-filing. This is to allow for more wholesome and robust engagement. It encourages early engagement. So if you're a developer and you're thinking through your various sites that you might have a project, you might start putting resources on the ground to start meeting with the community, start engaging with local leaders before you actually start talking about project logistics, and even before you bring it to the siting board, because the sooner you bring the local leaders into the fold and start having those conversations, you can have those without the tension of having a project looming over you. And it also provides balance, is that by providing public information, one of the things that we have heard and has been brought up throughout this proceeding is that community members sometimes come before a local board or siting board and say, I haven't heard about this project until 2 months ago. And it was because my local paper started to cover it. Meanwhile, that project might have had 3 local board hearings, might have had a couple of town halls. This allows so that for key stakeholders to know what's coming and to be more engaged earlier in the process. So that way there is an adequate level of due diligence that we provided and information sharing. And I would not take this timeline in any way to reflect how it actually plays out. Things can be mixed and matched, swapped around, except for the gray box, which is filing the application with the EFSB. The one note I will have is the new Division of Public Participation does issue an opinion on the status of of a developer's pre-filing engagement. So if a if the DPP determines that more engagement is needed, they can tell the developer to go and do more work in that space. But this is just again some of the milestones that can be met. So meeting with DPP and the Office of Environmental Justice and Equity, meeting with the MEPA offices, submitting a status checklist just to get, and that's a pulse check on how developers do it. And again, I just want to briefly go back to that slide for a second, Julie. One of the, if you notice in that right hand bottom box, the last one is provide updates on the CVA or CDP. Again, neither of these are mandatory in the application process. However, during this period, it is encouraged that developers explore conversations with community around development agreements or plans. We can move to the next slide. Do you have anything in the chat, Julie?
No.
Okay. Just some brief information on the Division of Public Participation, or the DPP. This is a new division that is primarily responsible for overseeing this pre-filing process and helping both developers and stakeholders engage in the process. One of their main mandates is also to oversee the intervenor support grant program and provide a liaison to help identify pathways and to help under-resourced groups be able to intervene in the regulatory proceeding.
Making sure everybody has Connor Rocket's contact information.
We gotta have Connor's contact information.
Very popular, Connor.
Yes, DOER, they are very popular. They're making the rounds. So let's get into the cumulative impact analysis. So this is one of the most interesting pieces of it. What a cumulative impact analysis is that for non-linear pieces of infrastructure generation, when they have settled on that sole site that they believe it to be the most optimal for development, they have to identify all the regions around that site contingent with, Julie, actually, if you want to move forward to the next slide, that would be helpful. With the prescribed SGA mileage radial distances in that top right chart. So what this means is identifying the burden community, identifying if there's any overlap between those radial distances and a burden community, and then having to evaluate through a scorecard whether it's going to materially exacerbate that burden community. From there, and then these burdens can also be positive or negative. And then based on that score, the developer has to then propose remedial action. These are typically if the scores are higher. One other note I'll make in our call out block is regarding a petition for a non-burdened area. So if, for instance, you believe that you're in a butter and you believe you're in a burdened area, maybe there's a brownfield site that has not been recorded around you, you can petition for an SGA and get receipt and for a CIA, but that's at the discretion of the siting director. So this is not to be viewed by the public as just because we don't like battery storage, that we can petition to try to get this battery storage project out of our area. So for the site suitability assessment, this is again getting into the scoring criteria. Again, they are ranked on a scale of 0 to 5. Lower scores are better. So some of this includes climate change resilience, carbon storage and sequestration, biodiversity, agricultural resources, social and environmental burdens, as well as various score modifiers. Some of these, what we want to have in this, especially for the benefit modifier, is it allows for to improve a project score when the applicant agrees to provide particular social or environmental benefits. The town has to sign off on any modifiers that would positively impact score, so i.e. lowering it. And there are, and Julie, if you want to go to the next slide as well, just a little bit more information on this. There's two ways, if for any reason there is any disagreement regarding a score, they can be corrected. A developer or municipality can apply a petition to EFSB within 30 days of the receiving of a score to say, and this is typically done only if it's viewed that the data is materially incomplete to render the score. So the GIS layers that the state uses might be outdated. You might have better data. If you can provide that better data, you might be able to use it to get a better score, or maybe even a worse score if you're petitioning from the town's perspective.
I think before we go on to the next slide, I do have a question that I don't want to get too far away from. We have a question. Could you speak to how these pre-filing engagement requirements differ from what was required before the law? And then in reality, how much were developers generally already doing these engagement activities, basically trying to understand the level of change and additional work required?
So for the pre-filing engagement, in previous to this, I was equated to the Wild West. Developers could do as much or as little as they wanted before submitting for various permits. Many developers are already doing the requirements in the pre-filing checklist when it comes to engaging with communities. However, what the law and the regulations put in effect is that bare minimum floor that every developer must now meet to be able before moving through the process. So it levelizes the playing field, so at a bare minimum, developers and communities understand what is at stake.
A quick question. The score that they receive for site suitability, if it is so lower is better. So if it's high, there's no consequence to having a high score.
There is. So a higher score means you're going to have to provide remedial action. So
okay.
And that could have increased costs to developers, and it's meant to dissuade development of less than advantageous sites. But that is why there is the score modifier process if there's material incomplete or contradictory data that compared to what the state is using.
So a couple more questions on site suitability. Are the scores combined? Are each of these site suitability scores combined for the final score?
So they are not combined. It's based on each category.
Okay. And then the other question is, when would a site suitability assessment not be required?
A site suitability assessment would not be required if it is an additional change on an existing facility. Let's move forward to slide 31. Oh, actually, this is a good one to stop on. We'll stop here, actually. So I know there's a lot of questions about community benefits plans and agreements. Again, there is no requirement that a community benefit plan or agreement is signed at the time that a project is brought forward to the EFSB or to the municipality. However, it is, wink and nod encouraged that there is conversations about one that happen. They are voluntary, but this is important leverage for communities to be able to extract benefits that they believe would be beneficial. So our perspective would be, if you're a municipality and you're thinking about a project, engage early with the developer, start that process, identify what needs you have and how those needs can be rectified through a community benefits plan or agreement. One caveat, a plan is not legally binding, an agreement is legally binding. And then consult your a stakeholder working group to identify those needs, try to have as many voices in the room. And then try to view this as a way to ensure that everyone's working in good partnerships. I will admit I am not a CBA or CBP legal expert in any way, except I do try to play one on TV. So we'll touch briefly on this. This is the constructive approval under 980 CMR 17. Again, so this is the process where we're in the closing stages at both the local and the EFS state level proceedings. And what this effectively is we, for whatever reason, we've taken on the application, we've been doing the process, and we just can't get to a decision in time. And the clock runs out. There is very few ways to pause the clock. Typically, it's been described as it's if there's active delay tactics, whereby either municipalities or the developer. But this is where it is to encourage the completion of the project and reach a decision in a timely manner. If it doesn't, there are those baseline conditions that are then applied that are stated through the application materials that a developer provides. I'll pause. Let's pause there for a hot second and see if there's any questions on all this. I know this is a lot of material on a lot of dense regulatory material.
Does what you just said include an opponent who might seek injunctive relief?
So if you are, so are you referring to if you're an abutter of a product site and the project is being done at either state and you're suing to prevent the project to move forward? So those appeals are only done through the SJC. So there has to be a decision that has to be reached. Because at that point, it's just purely speculation that there might be a project. That there still is that option that a project would be denied.
Yes, okay. So you're saying the court wouldn't hear it until
the court would. I cannot opine on how a court would handle those types of proceedings, but the understanding is that it would be better to wait until there is a decision before trying to preemptively derail.
Okay, thanks.
But the main purpose of the constructive approval, back to your question around carrots and stick, this is probably the largest stick in the regulations, and it's mainly to prevent the infinite pausing or resetting or delay tactics. So this is to prevent, say, at a municipal level, a group from trying to derail proceedings. So for instance, if your town council, let's say they're oppositional to a project, then they can just drag their feet. Like in the past, it used to be a case where you could constantly request more information, you can delay. Is that no? Once you hit that, once you have that complete misdetermination, that clock starts, and then when you get to that 11th month, or in this case, the 14th month at the larger level, and you don't think you're going to reach it, you have to start preparing for the constructive approval. However, that's just because you start preparing for it does not mean you can still reach a conclusion and issue a normal, a regular decision.
One more moment to breathe. We have a comments.
I'll save comments for now.
We can do comments at the end, but yes, we have time.
Yeah, I was gonna ask a question on that issue. So EFSB needs a lot more staff because some past things have stayed in limbo because it takes a long time for just the process to unfold. And what time period does when the proceeding closes, what time does the EFSB board have to make a decision? Are they have like a 30-day or?
It is that, so it's that 15-month clock.
Yeah.
So theoretically, anytime during that 15-month clock, they could reach a decision.
Yeah.
There's no obligation that they get to 14 months in 29 days and then they make that decision. What the EFSB can do is that again, they are just the final decision makers in the case. So again, Mass DEP, maybe DOT, they have say on a portion of the permits that are provided. And if let's say DEP comes back and says, you know, this air permit that this developer has put in, there's some work that has to be done. It goes back and the developer has to make those amendments. Those are done before the clock even starts. At that point, then the EFSB would oversee like a normal regulatory proceeding.
I'm just wondering, like, is the public hearing closed?
No, public hearings are open.
No, but at a certain point, evidence taking ends and it's decision time. Usually.
And those historically, though, any EFSB, frankly, any proceeding is open to the public. So they will notice it on a calendar. One of the things that the EFSB has done is they've created a docket notification system. So for instance, if you're a legal counsel, you've got 5 dockets you're monitoring, you can get updates when there's going to be movement in it. Still in the works okay, but what this way you can be at least aware of when that's on. And the tenant decision has to be discussed in public. So typically they will go, they'll have the evidentiary, they'll open the proceeding, they'll have an evidentiary hearing. There's no executive sessions or anything like that where they kick the public out. Everything is done hybridly, so you don't have to drive all the way up to the South Station. Now, given the World Cup, I don't even want to try to go around South Station. So the public can attend and they can see how the work is being played out. And there is opportunities for public comment. And the EFSB does welcome public comment because it helps them better understand how the sentiment around the project.
Have other states done this? Have we watched other states? Because we're usually like 3rd or 4th or 5th, right? We don't usually start this. Are there other states that have changed to a similar process that we could look
Not
at?
at this scale.
Not statewide.
Not at this scale. There's bits and pieces from New York, Michigan, Ohio, but this is really a first of its kind type of process.
So, because I'm just wondering if there's any way to look and see if there's or maybe there's a similar setup somewhere else that we can see if it's working.
That's why we're going.
Trailblazing.
We're trailblazing.
I know copying's a lot
It's
easier.
It's America 250, and this is the Commonwealth of Massachusetts, cradle of birthplace of America and birthplace of consolidated permanent.
Certainly, there must be states though that have like a streamlined permitting process, less governance over particular projects, where it is efficient. To detriment of whatever endangered species perhaps, but.
Efficiency and
Right.
You're not gonna like the response, and
No, but-
it's looking at places like
Like
Texas.
Right.
Yeah, I was gonna say Texas.
Right, so. And we're adding in this hugely important environmental and community piece, right? So are we comparing the timeline to those other states that have no consideration for that? This is all invented.
This is all on them.
Oh, that's so exciting, everybody.
And
I'm pretty excited.
the
All
EFSB
security.
they had asked the legislator for the past 2 years for extension to be able to really think through these regulations, and the legislator declined. So
Why?
they didn't want to take it up.
the ball's in your court.
We passed the law,
And
implemented. So let's get into this is really we went through the regulations. Now let's get into what it means for the public. So when you're at the grocery store, at your town meetings, and someone asks you what is happening with energy projects,
Happens all.
especially at the softball game. So again, we went from a decentralized, destructured permitting regime to a consolidated, streamlined version that we hope will work out with a spelled out appeals process with definitive start and end dates. There's increased developer participation in communities and encouragement for community voices to be heard. As well as there are greater protections. Instead of it being a case where it's on a case by case basis, there are new tools in place to help developers and communities streamline selection of ideal sites. Some of the other aspects that we've discussed, there's enforceable deadlines for meeting these projects. There's the new division of public participation, the support grant program to allow for greater agency and participation from the public. There's 2 tracks, so there no longer are communities having to have their workload overrun by projects that might be outside of their scope or outside of their capabilities, as well as 2 mandatory public meetings from developers in communities to be able to discuss the project. But again, that is just a minimum. So when you're thinking about community impact and you're starting to think about these regulations, at the beginning, we wanted just to highlight a few areas, some things to think about. Think about your community, take a look at the site suitability in the mass environment screen tool, understand where there's potentially overlaps, try to work through and think about the CIA and how that applies to your neighborhood and how you can potentially impact your local bylaws to avoid those potential areas. Overall, what these tools do provide is an extra layer of scrutiny and protections for your neighbors, friends, family. And knowing that what a product score tells you a lot more about what type of mitigation you might need to ask a developer for and what a developer will need to bring to the table and what could help develop with your development of a CBA or CPP. A little bit more information, just high level on the mass environment screen mapping tools, what it is, how it highlights burdened areas, and then how to use it. But I would say the best way to experience this is to go to the mass environment screen tool and actually click around and play around with the different indicators, the different layers, see how it interacts for your area. I should have played around with it a little bit more before coming in here today to be able to say, yes, this particular portion of Barnstable is a reasonable area to develop, or no, your entire area is blocked off in red. And by this, red is indicating that it's a burdened area, which means they're already going to need additional mitigation. And then just a little bit more on the cumulative impact analysis. The big takeaway is that it applies when there's an overlap of a burdened area, and then if it does not overlap, one is not required unless it is successfully petitioned by a group of 10 abutters or residents. But however, this does not mean for that 10 that you could have 5 from Barnstable, 4 from Yarmouth, and then 1 from Provincetown and petition. It has to be within the same geographic area. And then, as we discussed, here is some more information on the Intervenor Support Grant Program and just what it means for those who are applying.
And so we did have a question on this. Is
Yeah.
there any clarity on the Intervenor Grant Support Program that is expected to operate via Mass DPU, in particular the grant application guidelines?
So that is being overseen by the OEJE, the Office of Environmental Justice and Equity. They are responsible for putting together the guidelines. I believe they are already out in terms of how to apply. Again, one caveat is that municipalities with a population of less than 7,500 automatically are eligible for financial support. And then one other thing I'll note on that is that let's say you transfer the application because you lack resources to the EFSB, the municipality gains intervenor status in that proceeding, so you do get a seat at the table. And then where to get help. Dr. Connor Rocket. But yeah, no, we'll go to point 6 on that one. But if you need support, apply for support through the Intervenor Grant Support Grant Program. Find a docket on the DPU e-filing page. Get comfortable searching for DPU dockets. Renew has set up an entire page dedicated to public participation and how to just navigate finding dockets. Start putting together a service list of who are the key people that in your town that you want to talk to and think should be included in these conversations. Reach out to the DPP if you have questions about the engagement and try to have them start building those relationships early on. And then we covered this. Julie, can we skip to slide 45?
Was it time?
A readiness checklist. Go on.
I think it was the other way, right?
Yeah,
before-
other way.
Right before transmission.
There's too many windows
There.
open.
There, no. One more.
Back one more?
No, forward one more. One more. One.
Readiness checklist at the top.
Oh, I've got to exit out of mine. Rings. There.
So, I think this is a really good place to, I know we have a section on transmission infrastructure. I'm happy to talk about that with questions in particular, but I think this is a really good place to conclude the formal part of the presentation is that when you're thinking about your municipality and where you're at, I know just come out of town meeting season, so a lot of bylaws have been discussed already, but take the time to audit your bylaws, see if you can make changes and figure out if those change, how to make those changes as smoothly as possible. Identify your leads, who are the key people in the town that you want to oversee when you do receive an application here at a local level. Who are the key stakeholders that you want to have a seat at the table. Understand the clock. Before you get a project, run an exercise. If you take a project that you already have all the materials for and test it against your systems. See how can you meet that 12-month clock. You can simulate that in a course of a day. Again, you know this better than anyone else. Know your size. If you're over 75, less than 7,500, you can get intervenor support automatically. And make sure you educate your citizenry about the intervenor support grant program, because the more voices that are heard, the better the process plays out. And then, line up legal counsel. Some towns might not have the resources to have attorneys on staff, especially siting and permitting practitioners, but having the ability to have someone at the table who can help walk through the more technical components of an application or help you with your CBA or CPP are vitally important. And lastly, start thinking about the CBA and CBP. What are the resources you need? What type of takeaways do you want to have? And how can you bring those, make sure you maximize that without the process coming across as being a confrontation. We have some other resources in this deck, including email addresses and links to be able to find additional information. Thank you so much, everyone, for joining us today. Happy to answer any questions or receive any comments.
Bring that comment.
You want the comment?
I will take the comment. And then Julie, I just want to switch one more slide. We can put the thank you note.
Sure. So the comment is just as a professional electric engineer in Maine, not Mass, I would say that a modern grid isn't a thing. If you aren't engineering with an intentional goal of optimizing the use of the grid, nothing that you install will make the grid modern. Most of what I'm pushing to use isn't new technology. It's been around for 10 or 20 years. In some cases, there has been significant change due to the reduction in cost to deploy it. Other options haven't changed at all. We just need to use them.
Noted.
Good note.
So Dan, Katie, thank you so much for the opportunity this morning. Great discussion. Happy to, if there's any other questions, or we can move towards a more structured. And if anyone has any questions that they think of after today, my email is on the screen. So please feel free to reach out if you want to have a more in-depth conversation. We're also happy to have that as well.
Thank you very much.
Yeah.
It's to some degree, I felt like this was a game of Stump the Wizard, because really testing how much do you actually know about something that's really hard to get your arms around.
It hasn't been implemented.
Yeah, I mean, I'd be happy to give you like from a 10,000 foot view. If you look at places like Texas, there are a lot of ways to try to achieve goals. And one is to deregulate and let the market, give the market freer range. And the other is to really try to make the regulatory framework so predictable and so concise that investors are not going to get disheartened and walk away. I'm not sure whether we've gotten there. I mean, I was consciously forcing myself to look at this through the eyes of an investor, sitting at the table, being convinced by a project developer that this is where I wanted to invest, and trying to think about whether or not the framework of the new legislation actually gives me more peace of mind. And the honest answer is I don't know. I think this is going to have to play a little bit, but I like doing metaphors. I'm going to give you a metaphor, okay, for how I see this whole process, and it concerns me. I'm a zookeeper and I have a pen of lions. And I've decided that what I'm going to try to do is get the lions to act like lambs. And I put all my energy into training the lions to be like lambs, as opposed to the zookeeper across town who says, I've got a pen full of lions. What I'm going to do is designate areas for the lions to do what lions do, and then encourage them to do that and have a friendly way, a safe way for people to observe lions doing what lions are doing. That is Texas. Probably not, because they're probably not designating. And trying to get lions to act like lambs isn't going to work. And so I try, because one of the things I can't get out of my mind is the whole idea of when market solutions work and when they don't. That is, when you create a framework where investors and developers and the private sector is going to do what is in the best interest of long-term public policy and outcomes. And I don't think we're even close to there in just about any sector. And I would include energy in this sector. I don't understand why. And so this is both political parties succumbing to market solutions being the answer. Where if you really broaden this out and say what the government's role should be doing, both locally and from a state perspective, is developing goals, which we have done, but also designating areas and ways to do things, and then putting out RFPs to the private sector to actually deliver that. Instead, it's sort of like an opaque whack-a-mole process where an investor says, I'm going to try this because I think it'll fit there. And that's a very myopic view, because it's not a process that really, it engages the public by necessity, but it doesn't represent the public interest. It allows for public input, as opposed to a really good government process, which would actually, from the beginning, engage the interest. I like the comment about sort of the grid. A modern grid is not necessarily, because right now we should have a 20-year view of what a grid needs to look like, with distributed inputs and smart metering and everything we know needs to go into, including, as you pointed out, the data centers and the almost insatiable need for electricity that we're going to have. So that's a comment. I mean, I'd love to see a reaction. You guys exist because we need you to actually help us understand how to deal with the labyrinth that and Chris, I'd love to hear your thoughts on sort of the big picture of this and how it fits in from an environmental standpoint. Because if we do nothing but make it really hard to do stuff, we are in a way conservationists and protecting sort of open space and areas that we don't want to see development. And some of that is environmental justice. It's not all, I mean, some of that is economic justice. It's not just around environmental justice. But is that going to deliver what we need to see delivered over the next 20 years?
Short-sighted.
Yeah, that's the problem I have.
This is a really good comment and question, because we haven't reached the implementation stage. We have regulations, we can play paper exercises until we're blue in the face. And we can think that we have everything down, but we're still gonna have people, whether we give them all the information in the world, who are still not gonna be aware of what's happening. And what's to prevent, to your point on financing, you're providing certainty in the sense of you're gonna either have 12 months or 15 months. Okay, great. We know you're going to minimally get your permits approved. How long is it gonna take for you to build? What other processes and procedures exist outside? In reality, this is, when you look at the bigger picture of project development, this is really that -1 contingent area. We're not at the starting point, we're at the construction phase. And what this proceeding does, this doesn't answer some of those questions about project financeability. And other than you have certainty in timelines. But even then, you don't know how long your pre-filing engagement's gonna last. And then if we can't even get into what happens if it's appealed to the SJC. How long does the SJC take to remedy this? What if they remand it back down to the EFSB? These are questions that haven't been addressed, and these are really important ones to be having. The challenge with this is that the legislature didn't extend the timeline to give ample room for the gamification of their designs. So since Renew has been involved in this for more than a year, since the straw proposal phase last spring, we have seen them go try to find the best way to balance everyone's needs, but we haven't seen the actual what is this show, and how is this going to play out, and what does this look like? I think that's a really fair question, is to say, how many projects are we expecting? What's the likelihood of success? How much work is the EFSB going to be put under? What does engagement look like? Do they start defaulting just simply, okay, check the box, you hit the minimums, great, let's have your application? Or are they going to really respect the diversity that's needed in engagement? These are things that we're gonna see play out in the coming months ahead. What we can anticipate probably is there's going to be another proceeding to amend these rules, because inevitably something is going to break. And it's going to be in a way that no one thought about, because we haven't been able to actually test it against a new project. We've been testing it against existing projects, and it's easy to make assumptions when you know what the end result is. I kind of go back to that scene in the Sully Sullenberger movie with Tom Hanks, where he's sitting in, I believe it's the FAA hearing, and they're demonstrating the ability to have reached Teterboro Airport.
Right.
And they keep saying, like, oh, you could have made it to Teterboro. And Tom Hanks saying, well, how many times have they worked in the simulator? In this case, the simulator being the existing project. You can have as much time as you want in the lab to get to the perfect ideal result. But as soon as reality hits, you're in an entirely different ballgame. And that's where that's where we don't know, is what happens when you have that first solar project, that first BESS project. What happens when you have that first transmission line? That's going to be where the rubber meets the road.
Other than existing utilities, are you seeing a lot of new entries from an investor standpoint?
From an investor standpoint, it's at the small level where you don't have as much insight into what that looks like, because that's really on a case-by-case basis. At the larger level, it's strictly through the RFP process. That is the single greatest market signal to developers. And right now, we're sitting here at a time when there's an energy affordability bill sitting in this, getting ready to come out in the Senate, maybe as early as next week, that has massive procurement reform implications that could send new market signals to how clean energy is even brought about in Massachusetts. And the concern with that language is that it's insufficient to actually spur that investment.
Is that the one that includes nuclear as well?
There is an amendment that includes nuclear, but that's not tethered to the procurement section. So in reality, it's always the fault of legislators in many ways, and I don't want to come across as derogatory towards them, but they look very short term versus looking at the bigger picture and trying to think 20 years out. They look going as far as the next election.
And actually that's their role.
Yeah.
You again, the lion and lamb thing.
Yeah.
You don't expect investors have a window that's predictable and we know what it is. Government's role is to say, okay, generationally, how does this play out? They're not doing their job.
No.
What they're trying to do is in very short term, get the investor group to feel comfortable doing things that may or may not be in their best interest generationally. And again, I mean, this is not your presentation was great, and what you guys are doing is essential and much appreciated. But it
Doesn't address larger.
well, it's a reset button, because if we're going to have good energy policy, this long-term energy policy, it has to start with people who are not looking at next quarter or next year's earnings. It has to start with where do we want to be in 20 or 30 years, and then getting the private sector to figure out how to make money doing that. And the offshore wind thing, where is that landed now?
So the offshore wind, from a policy standpoint, they're still very encouraged by it. They want to be able to support the industry. I think there's still a lot of appetite in the halls of Beacon Hill to support it. That being said, federal headwinds have made it nearly impossible to actually bring it about, unless the project's already been well under development. But even then, there's ongoing threats, and there has to be conversations about what the ones that haven't started development, are they going to take the buyout, like we saw with Total Energy.
Have they taken the buyout yet?
The only one that we have heard of is down in the Mid Atlantic with Total Energy.
In California, there's somebody that bought.
I will say I flew a few weeks ago from here down to Philadelphia offshore. I could not believe the amount of offshore wind that has been built in the last 5 years. And I've been doing that flight for 40 years. It's really encouraging. Off in New York City, for example, there's a ton of foundations. There's nothing on them yet. And my concern is we got to a certain point and now it's been stopped. But that work is still there. I assume can be picked up if the world ever goes rational.
Hopefully. But so now one of the conversations is, what about Canada? We like looking to Canada as our energy solution. Nova Scotia is exploring, they have a grid that's about 2.5 gigawatts, which is pales by multiples of the New England grid. But they have the capacity to build over 60 gigawatts, I believe it is, of offshore wind. And they are going to put a plan in place to develop those 60 gigawatts. They want to develop those 60 gigawatts.
And then all the data centers will be up there.
Well, but the challenge is they don't have the transmission infrastructure they want to connect it to the New England market. And so that's what the next logical goal is going to be is, well, if they build all this offshore wind, we'll have to interconnect with the Canadians. And that requires presidential permits. But right now they're prioritizing instead of north-south, they're going east-west, so inter-Canadian.
Okay.
Yep. Thank you very much.
Thank you. Thank you everyone for joining us today. If you have additional questions, please feel free to reach out. And we're happy to continue the dialogue.